University occupied camps, are they legal? Let me make 10 really important points. Point 1. To be very clear, this post provides legal information only, not advice, to outline a number of areas, including how the university may approach such camps and to outline how the university may interpret the legality of the camps. Please do not rely on this post to base your decision making, but do obtain specific legal advice on your protest related activities. Point 2. Some university leaders may have made it very clear they do not allow camps or tents to be erected at all across the university campuses. Or these universities may have explained to students they have allowed camps for a short period of time at particular locations. Thereafter, they will take legal steps to remove them. Or other universities may yet to have formulated a final position on such encampments. Point 3. From a human rights perspective, you as a student should know that the starting point is that you, like anyone else, has a positive legal right to peacefully protest. This right is a positive right given to people in the Human Rights Act, freedom of expression, Article 10, and freedom of assembly, Article 11, the two most prominent human rights. In practice, this means the university authorities and police must facilitate and support students' right to peacefully protest as long as the nature of the protest is peaceful and non-violent, and the protesters are acting in accordance with the law. You should remind the university of these rights and their obligations to comply with the important human rights to peacefully protest in writing and in meetings, and what your specific objectives are of setting up camps at the university, and what your specific activities will be, e.g. talking, sitting, praying and singing. Point 4. As students, you should know the right to peacefully protest is not an absolute one, but a qualified right. This means you as a student do not have an absolute right to peacefully protest, including in a camp. The right to peacefully protest can be lawfully interfered with and limited either by restrictions, by imposing conditions on the protest camp, or by banning the camp altogether. Whether it's restrictions or banning a camp, there is basically a three-part test to be met. A, there is a legal basis to limit your right to peacefully protest in a camp. B, there is a legitimate aim behind the limitation over the encampments. And C, the limit on the right to protest in a student camp must be necessary and proportionate. Let me further explain and give some points to consider for you as a student in these camps as a matter of urgency. Point 5. When it comes to the legal basis to limit your right to peacefully protest in a camp on university grounds, the university may point to a number of laws the camp is breaking, including the camps are erected on private university land and the prohibition of students in occupying private buildings if that's taking place, and information the university has received accusing some protesters in camps of criminality, if that is one of the accusations. The latter should be challenged if untrue in writing and meetings as soon as you are made aware of them. From a human rights perspective, even if there is a legal basis to limit your legal right to peacefully protest in a camp, the university cannot limit the right unless two other tests are met. Point 6. So the second test is the university must be seeking a legitimate aim to limit your right to peacefully protest by erecting and living in tents on their private land. The most common limits mentioned in Articles 10 and 11, which the university might point to, are preventing crime or disorder, protecting public health, and protecting others' rights, e.g. their education and well-being. The university authorities need hard evidence and facts which are accurate, current and reliable that it is pursuing these legitimate aims. As students, you must challenge any information which is untrue or exaggerated. As students in these camps, you must not damage the university land or buildings via protest-related activity, e.g. drawing on the walls or other structures, and intimidate or threaten others, including counter-protesters and agitators, and display posters which are likely to cause harassment, alarm and distress to others. Those students organising the camp should carry out a written risk assessment and implement specific actions, including appointing stewards and legal observers who do not participate in the camp, and cleaners ensuring the camp remains clean. And you should seriously consider filming the camp at all hours of the day and night for accuracy, record and evidence keeping. and post such videos to demonstrate the peaceful nature of the camp and adherence to the risk assessment. Point 7. The final test must also be met. According to human rights, the university can only limit your right to peacefully protest in a camp if it is necessary and proportionate. This means the limit should only go far as is necessary to carry out those legitimate aims mentioned earlier. The university must also look at whether how they are policing a camp is proportionate. This involves a balancing rights exercise. On the one hand, your right to protest in a camp peacefully, and on the other hand, other people's rights, including students and staff who are not protesting in the camp. And this is likely to include an assessment by the university whether or not your camp is seriously disruptive to other students and encouraging any kind of criminality. Consider urgently issuing a do's and don'ts list to those in the camp and those supporting the camp using social media if you haven't done so already, and send out reminders, log the date and time when this was done. And you are strongly encouraged to use lawyers to give training on do's and don'ts at a protest camp. What is important to know from this assessment into necessity and proportionality is the university may decide to either restrict your protest camp by imposing conditions or to take steps to remove the camp altogether. Point 8. A decision to restrict the right to peacefully protest in a camp might include imposing conditions on the camp, e.g. to keep tents limited to a particular location or numbers, to remove tents at a particular location, not to block entrances to university buildings and stop students from, say, studying at the library, and not using particular noise equipment at particular times, e.g. when exams are taking place or late at night. Point 9. Alternatively, the university may decide to remove the protest camp by applying to the court to obtain a possession order, an injunction, with accompanying enforcement powers involving using security, bailiffs, and the police to use force to remove you and the tents, or use new police powers to remove the protest camps as instructed by the university. And in some circumstances, the government can get involved also by banning static protests. Point 10. Finally, remember, the university needs to communicate any decisions to any person who are part of these camps and give notice before taking any enforcement action. Finally, universities are keen to maintain its reputation as a high-quality educational provider and have a positive publicity in the media and be on the right side of history. You might want to remind them of these points when explaining your clear objectives of what you are doing by being in a camp and what you expect of the university. Seek legal advice on how to comply with the law, to help effectively liaise with your university authority, and to know the consequences of breaching the human rights law. Stay safe and legal. Feel free to comment, follow, like, and share.